Bonjour and welcome back. This video will discuss real right, and there will be two such videos. We will start trying to give a definition of real right, discuss things and their divisions, and focus on principal real rights. And the next video will discuss accessory real rights. So what is it that we're talking about? We say that these rights are real because they are exerted directly on a thing. That comes from the word res in Latin, which means the thing. Such a right enables the holder of the right to draw from the thing either all or part of its economic advantage or substance. And we will see that such rights are protected against anyone interfering with the said right. And this protection is also known as protection against the whole world. We say that real rights are protected erga omnes in Latin, which means against all, and not just against a particular party, as we have seen with personal rights that are protected inter partes. To understand the scope of real right, what is the object of real rights, let's visit rapidly the categorization of things, and I will use the Louisiana Civil Code. And the very first articles of Book 2 discussing things and the different modifications of ownership. According to Article 448, things are divided into common, public, and private, corporeals and incorporeals, and movables and immovables. Let's address rapidly the distinction between common, public, and private things. Common things belong to everyone, like the air we breathe or the high sea. Public things are controlled by the state and its agencies. And we focus in the Civil Code on private things, things that can be owned by individuals or other persons, such as juridical person acting under private law, primarily business associations. So according to Article 453, private things are owned by individuals, other private persons, and also by the state or its political subdivision in their capacity as private persons. The second distinction is between corporeals and incorporeals, and let us look at them in parallel. Corporeals, as defined in Article 461, are things that have a body. Corporeal comes from corpus, which is the Latin word for body. And so these things must have a body. They must be tangible, whether it is animate or inanimate. Animate would be an animal. An animal you own is an animate thing. It can be felt or touched. So with corporeals actually describe tangible things. Incorporeals are things, says the same article, that have no body, but are comprehended by the understanding. And the article gives examples: right of inheritance, servitudes, we will discuss servitudes in this video, obligations. You can own an obligation. You can own a right to be paid at a certain date. This is incorporeal. Right of intellectual property, like copyright. You can hold the book or the piece of art in your hand, but you cannot hold the copyright, the right to be paid for every copy of the book being sold. So all these are regarded as things under the civil law. All these things can be owned. All these things can be the object of real right. I know it sounds counterintuitive, when you discuss incorporeals, but this is the way the civil law works. So incorporeal are intangible things. The last distinction that appeared in Article 448 is between movables and immovables. Movables, and I give you here Article 471, are things, whether animate or inanimate, that normally move or can be moved from one place to another. Furniture is typically movable. A car is movable. A book, most things we use in daily life are regarded as movable. And I will discuss 475 after. Let's see first what immovables are. Tracts of land with their component part are immovable. You cannot move land. You can move dirt, of course, but the dirt you put in a bag or in a truck becomes movable, actually. But the tract of land itself, or whatever is built on the land, or whatever is growing on the land, is regarded as immovable. Why is the civil law making that distinction? It makes that distinction because there are special rules regarding, for instance, the sale or the donation of immovable. There are rules regarding registration. We keep public registry of transactions on immovable. And that's why it is so important to distinguish movables and immovables. However, the distinction is not always obvious or easy, because the tree that you grow may be regarded as immovable, but you may want to sell the crop of such tree, the oranges produced by this. Is it a sale of immovable if they are still growing on the tree? The Civil Code is answering all these questions, but has also this provision that you have here on the left, Article 475, all things corporeal or incorporeal that the law does not consider as immovables are movables. That's a very important article. It's telling you that by default, all things are movable. To be immovable, they must satisfy the definition of Article 462 and following. So I come now to real rights. Real rights are rights that are exerted on things, whether public or private, corporeal or incorporeal, movable or immovable. And these real rights can be principal or accessory. A principal real right is a right that pertains to the substance of the thing that is placed to the service of the holder of the right. You exert that right on the thing itself. For example, ownership is a principal real right. Usufruct or habitation, right of use, servitudes that we will discuss in a few minutes are principal real rights. Accessory real rights are real rights that are accessory to an obligation, actually to guarantee the payment. They are rights such as mortgages, pledges, privileges on immovables and sometimes on movables. We will discuss accessory real right in the next video because they are really a particular category of real rights. From now on, I will focus on the principal real right. You still with me? I know it's a lot of abstract categories, and let's get into the principal real rights. Chapter 2 of the first title of book 2 is discussing the rights in things, which is another way of expressing a real right. And 476 tells you that one may have various rights in things, ownership, personal and predial servitudes, and such other real rights as the law allows. Take a deep breath and let us start our exploration of these real rights. Let us start with ownership. which is known as the most complete real right that you may have on things. And if you read 477, ownership is the right that confers on a person direct, immediate, and exclusive authority over a thing. Okay, it's the most complete right that you can exert on a thing. It goes on saying that the owner of a thing may use, enjoy, and dispose of it within the limits and under the conditions established by law. The right may look pretty strong, but there are, of course, plenty of limitations out there. So let us try now to analyze the structure or the DNA of ownership in the civil law tradition. And you'll be happy because it's a rather simple definition that we have inherited from Roman law. Here it is, the most complete real right or ownership. You have to remember a trilogy here, usus, fructus, abusus. Okay, those are the Latin words. Try to pronounce them on the evening of Halloween and let's see what will happen. Usus is the right to use or enjoy the thing, okay? To live in the house that you own or to use it to make profit, putting it in the market, letting it and receiving rentals. You can use things in many number of ways. Fructus is the right to derive fruits or income from the thing. The word comes, yes, from fruit, because originally, anthropologically, when you were controlling land, you wished to control the resources, what was growing out of that land. Fruits growing out of trees, but also anything that grows. And in law, in the civil law, yes, fruits include vegetable as well, okay? So the word fruit in the civil law is a generic to describe any income that a thing may produce. We are talking about natural fruit, what is growing out of the land, or civil fruit, which is income like rentals that you get from a house you own. So you see, you can use and derive income from what you own. These are the two most important characters of ownership. But there is something else. The right to abuse, abusus. It's the right to dispose of the thing. You may want to get rid of it. You may want to get rid of it against money by selling what you own, okay? And buy other things that you like better, or donating if you are a generous person. But you may also, and we do this all the time, you may abuse or dispose of things by destroying them or abandoning them, whatever you trash or get rid of. You exert actually your right of ownership. You own this bottle, you used it, it was full, it's empty. Put it in the recycle bin, please. Few people do that here in Louisiana, I noticed. So you have here a full description of ownership. Isn't it nice? 3 words actually to remember. And then you know what it means to own in the civil law. Now, Louisiana law, like other jurisdictions, allows you to dismember this full and complete right that is called ownership, to split it into smaller rights. That's what dismemberment means. And here I cite to 533 saying that 2 kinds of servitudes, personal servitudes and predial servitudes. Okay, servitudes are kind of dismemberment of ownership. Let us see what we have behind these words. Personal servitude, according to Louisiana law, is a charge on a thing for the benefit of a person. And there are 3 kinds of those: usufruct, habitation, and the right of use. If I take habitation, ownership of the house means you can do anything, including residing in the house, etc. Someone who just has the right of habitation would have the right to live and reside in the house, but would not have the right that the owner has to put it on the market to receive rentals, doesn't have the right to sell it. It's a much more limited right, okay? For reasons, for some reasons, this right of habitation is considered as a personal servitude because you benefit from the personal right to reside in a house that belongs to someone else. Predial servitude, which are known also as a real servitude, real as opposed to personal, is a charge on a servient estate for the benefit of a dominant estate. The two estates must belong to different owners. I know these articles sound awfully abstract, and we will illustrate this with examples in a moment. Before I get there, I want you to have a visual of this division between personal and predial servitudes. You may come back to this once you have understood what usufruct is, right of habitation, right of use, natural, legal, and conventional servitudes. Let us start with usufruct. Remember that ownership is having the use, usus, fructus, the right to have the income of thing, and abusus, the right to dispose of thing. You may split ownership, giving usus and fructus, the use and the income, to one party called the usufructuary, and another party will keep the right to dispose. You'll tell me, Professor, that doesn't make sense. Well, let me give you an example. Imagine a married couple living all their life in a house that belongs to the husband. At the death of the husband may want to allow the widow to keep living in the house and give her not only a right of habitation, but a stronger right. You may create in the will a usufruct. The widow will be usufructuary, meaning that as long as she lives, she has the right to use and derive the income of the property. The duration is always limited. Typically, the usufruct is a life, ends, with the life of the usufructuary, or you can have a term also on the usufruct. It is quite good for the widow because she may decide to keep living in the house and go like before, except that the husband is no longer here. But she may, if she has to move to a smaller place or nursing home, put the house on the market and cash the rentals and pay for this smaller place with the rental or pay for the nursing home. Okay, but she has a real right. She cannot be dispossessed of this right, which is much more better than a personal right. And the children of the couple will be regarded as the naked owners. They simply keep the right to dispose, resell the house, but there is little point in reselling the house as long as mom lives there, because the buyer won't have the right to reside in the house or get benefit from it, because the buyer is just buying the naked ownership, so a limited right. So you understand from that example that we are dismembering the full real right that ownership is, giving two elements to one party, and the remaining element, the right to dispose, to another. The right of habitation or the right to use resemble the usufruct, but are not as complete. The right of habitation is the non-transferable real right of a natural person to dwell in the house of another. You simply have the right to reside here. If you can no longer reside in the place, you cannot let it and cash the rental. It's not as complete. You see, it's just the usus that you have. You don't have the fructus in that case, the right to have the income. And the right of use is simply uh, a right in the favor of a specified use on an estate. Uh, for example, you may have a hunting right on land that belongs to someone else. This right is personal to you. You are the holder of that hunting right, okay? It's less than full enjoyment. You cannot cut the trees, for example, in the forest where you can hunt, but you can go there and shoot animals. These animals will belong to you. So it's a simple right to use. Interestingly, Louisiana call all these personal servitude. The word does not appear in the French Civil Code. The French don't like the concept of personal servitude because it is a remnant of feudalism, you know, where people were had all kind of duties on the land of another, and the advantages that they were getting out of that were very minimal. But we didn't have the experience of feudalism in Louisiana, and therefore it's sort of out of convenience. We regard usufruct, right of habitation, and right of use as personal servitude because one person can get service or can use the land that belongs to someone else. Let's get now at the predial or real servitudes. We're talking, I gave you the definition earlier on, and Article 646, it explains actually that it is a relationship that exists between two tracts of land that belong to different persons. One of the estates is called a dominant estate. It means that whomever owns or possesses this estate will enjoy the benefit of the servitude. And the servient estate is the estate that must allow the use of the servitude. So whomever owns or possesses this estate must allow the use of the servitude. A typical example is the right of way or right of passage that the owner of a dominant estate may have on a servient estate. Look at this situation here. It shows 4 tracts of land. You have A, C, and D, you see, have direct access to the road, okay? But you see that lot B is landlocked. So whomever owns B can have very limited enjoyment because unless you use a helicopter, I don't see how you're going to access to B. So according to the law, the owner of B has a legal servitude, a right of passage through the neighboring land, and typically it is exerted on the land that gives you the shortest access to the road. You could use it actually on A, but why not also on C or on D? And by the way, these servitudes can be created by contract. Very often they are created when you divide the land and create a lot that is landlocked. You will create a right of passage on the right of another. This is a servitude. And the servitudes run with the land because if B sells his land, the purchaser will benefit from the servitude. If A is selling, or the owner of A is selling A, the buyer of A will have to accept the limitation caused by the servitude. Let me go back to 654. It tells you that servitudes can be natural. A natural servitude is arising from the natural situation of the estates. A typical one is servitude of drainage. People who live on the hill have to accept and collect the waters that are coming from the land above. They cannot object to this running water. That's just Mother Nature taking its course. Legal servitudes are imposed by law, like when the land is landlocked, as in the example I gave, but you can also create voluntary or conventional servitude by contract when you want one land to have a benefit over another land. You understand that servitude are far more limited than ownership, okay? But as one say, they run with the land. So whenever a land that is subject to a servitude is donated or sold, the servitude follows, with the right of ownership. You have here the articles about the right of passage. You can read them in the code or on the slides. Actually, the law says that when the right of passage exists by law, usually you should take the passage in such a way that it causes the least inconvenience for the one who suffers, the use of the servitude. And it should be nonetheless sufficient passage for the normal exploitation of the dominant estate. And in the next video, we will discuss accessory real rights. I will meet you there in a moment. Thank you for your attention.